cuando usted se encuentre bajo custodia. Durante todo este proceso, usted tiene el derecho constitucional de guardar silencio. Si usted elige decir algo, cualquier cosa que usted diga puede ser utilizada contra usted. Todo lo que se diga donde yo me encuentro, así como donde ustedes están, se está grabando. En la sala del juzgado se encuentra presente conmigo un fiscal asistente del Estado, escuchando todo lo que se dice, de manera que por favor no diga nada sobre el delito en sí. Sírvase tener estos derechos presentes a medida que avancemos por el proceso. Por favor, cuando se llame su nombre, colóquese frente al podio. Gracias. Thank you, Your Honor.
Thank you. Let's first call up Mervyn Arcaya Bermudez.
Mervyn Arcaya Bermúdez.
Sir, you're here being held on 2 charges.
Señor, usted está aquí porque se le retiene en la cárcel por 2 cargos.
The first charge is dangerous excessive speeding, and the second is reckless driving.
El primer cargo es circular a una velocidad excesiva, peligroso, y el segundo cargo es manejo atrevido.
Sir, do you want me to appoint the public defender, or are you going to hire a lawyer that you choose?
Señor, ¿usted quiere que yo le asigne el abogado de oficio o va usted a contratar un abogado de su elección?
Lo asignen.
Perdón, señor, repita.
Que asignen el abogado.
I want a lawyer assigned to me.
I'll provisionally appoint that office.
Provisionalmente voy a asignar esa oficina.
I reviewed the affidavits and find probable cause for the 2 charges.
He revisado el affidavit y encuentro motivo fundado para los 2 cargos.
Your bond will be set at $1,000 on the dangerous excessive speeding.
Su fianza va a ser fijada en $1,000 para el cargo de circular a una velocidad peligrosa excesiva.
It'll be set at $2,000 on the reckless driving.
Y va a ser fijado en $2,000 por el cargo de manejo descuidado peligroso.
He does have. Has an ice. Yeah, there's Sir, you have an ICE hold, so I'm going to ask the clerks to prepare a detainer for my signature.
Señor, usted tiene una orden de retención de ICE, por lo tanto voy a solicitarle a las escribanas que preparen una orden para retenerla a usted para que yo la firme. Pase a su izquierda, por favor, señor. Ya terminó.
Ms. Hernandez, we're going to have to take a quick pause. We're having some computer difficulties. Our IT department has been notified.
Okay.
So we're just going to be in a holding pattern, everyone, to hold tight until we get those corrected.
Thank you. Yeah, I will be.
All right, folks, our clerks have got their computer problems fixed. Pre-trial release is still struggling, but I think we're going to make a go of it and give them time to get it fixed. Next up is Jose Luis Martinez.
José Luis,
Sir, you're being held on one charge of operating a motorcycle without a license, an endorsement.
señor, se le acusa y se le retiene la cárcel por un caso de operar una motocicleta sin tener un endorso.
Are you going to hire a lawyer or do you want the public defender?
¿Va usted a contratar un abogado o usted necesita que se le asigne un abogado público? Señor,
Es correcto.
what he says is correct, but
Sí.
Sir, do you want me to appoint the public defender?
señor, ¿usted quiere que yo le asigne un abogado de oficio?
No entendí.
I don't understand.
Sir, are you going to pay for a lawyer to represent you or do you want me to appoint one to represent you?
Señor, ¿va usted a contratar y pagar un abogado que lo represente a usted o quiere que yo le nombre, le asigne un abogado que le represente a usted? ¿Qué quiere?
Sí, está bien.
Yes, it's fine.
All right, sir, I'll appoint the public defender to represent you.
Muy bien, señores, yo le voy a nombrar un abogado de oficio para que le represente a usted.
Your charge has been upgraded 1 degree because you're in this country illegally.
Su cargo ha sido aumentado un grado porque usted se encuentra en este país ilegalmente.
I find probable cause and set your bond at $1,000.
Encuentro que hay motivo fundado y fijo su fianza en $1,000.
Because you have an ICE hold, I'm going to ask the clerks to prepare a detainer for my signature. Step to your left.
Usted tiene una orden de retención de ICE. Voy a pedirle a las escribanas que preparen una orden para que yo la firme. Pase a su izquierda, ya terminó.
Next up is Kervin Trujillo Mendoza.
Erwin Trujillo Mendoza.
Sir, you're here having been held for one charge of driving without a driver's license. It is enhanced 1 degree because you're in this country illegally.
Señor, usted está aquí en la cárcel porque se le retiene por un cargo de manejar sin tener una licencia de conducir. Este cargo ha sido aumentado porque usted se encuentra aquí en este país ilegalmente.
Do you want me to appoint the public defender?
¿Quiere usted que yo le nombre un abogado público?
Sí.
Yes.
You're appointed.
Le queda nombrado.
I find probable cause. I set your bond at $1,000.
Encuentro motivo fundado y fijo su fianza en $1,000.
Okay.
Ok.
Mr. Trujillo up. Yeah. Kervin Trujillo Mendoza. That's an ICE hold. Sir, you have a hold for I. Ask the clerk to prepare a detainer for my signature.
Señor, usted tiene una orden de retención de ICE. Voy a pedirle a la escribana que prepare una orden para yo firmarla.
Step to your left, please.
Pase a su izquierda, por favor.
Artemio Cordova Melchor.
Artemio Córdoba Melchor.
Is that the one you're here for?
Yes, sir, Judge.
It's a lucky one. That was the next one on the list. Sir, you're being held for a charge of domestic violence battery.
Señor,
Mr.
a usted se le retiene en la cárcel por un cargo, un delito de violencia intrafamiliar, agresión física.
Mr. Ladd, are you here representing this gentleman?
Yes, sir, Judge, for the duration. I was hired yesterday evening. Told the family I would be here today. Judge, I've read the affidavit. I know I'm not here to argue with you about it. It was just first appearance. I would bring to the court's attention, my client does own his own home. He is 75 years of age, will be 76 in June. And I can tell the court that he has medical issues, specifically diabetes, and that he does have daily medication that he needs. So based on the facts and circumstances of the case, I was hoping that the court would straight pre-trial release him. It's his daughter that hired me to represent him.
I'm sorry, ¿está usted representando a este caballero? Sí, señor, lo estoy representando por la duración de este caso. Me contrataron ayer el juez, yo he leído el affidavit y no estoy aquí para discutir eso con usted. Esta es su primera comparecencia y yo quiero que el juez esté al tanto de que mi cliente es dueño de su propio hogar y que ya va a tener 75, o que tiene 75 años y va a tener 76 en junio, y que tiene también problemas médicos, específicamente diabetes, basándonos en los hechos y las circunstancias, y que estoy esperando que el juez pueda ponerlo en libertad previa a juicio directamente. Su hija me contrató para que lo representara.
And judge it for the record, he and the victim are father and son, and they do not live together. They have separate houses.
Y juez, para que conste en el acta, él y la víctima son padre e hijo y no viven juntos.
Looks like the only thing I see as far as a record is from 1980. Can't even make out what it is, but it looks like he did about 90 days in jail in Texas.
Parece aquí que lo único que puedo ver aquí en lo que respecta a antecedente para el señor es de 1980. No puedo realmente entender qué es, pero parece que él cumplió con 90 días en la cárcel en Texas.
Sir, I find probable cause for the charge.
Señor, encuentro motivo fundado para el cargo.
Taking everything into consideration, I am going to straight pretrial release you.
Tomando todo en consideración, voy a ponerla a usted directamente en libertad previa a juicio.
You'll be getting out of jail today without posting any monetary bond.
Usted va a salir hoy de la cárcel sin necesidad de depositar o pagar ningún tipo de fianza en efectivo o dinero.
I'll give you one business day, meaning tomorrow you have to report to pretrial and sign up with them in person.
Le voy a dar a usted un día de tiempo. Esto significa que mañana usted tiene que presentarse y reportarse en la oficina de libertad condicional y firmar con ellos en persona.
While your case is pending in the system, you have to call them once a week on Mondays.
Mientras que su caso siga pendiente o siga su curso en el sistema judicial, usted tiene que llamarlos a ellos, a esa oficina, una vez a la semana, los lunes.
You have all the standard conditions of pretrial, plus the following special conditions.
Le van a aplicar todas las condiciones estándares, más las siguientes condiciones especiales.
You're not allowed to use, possess, or carry firearms, weapons, or ammunition.
No se le permite a usted ni utilizar, ni poseer, ni portar armas de fuego, armas en general o municiones.
You're not allowed to have any intentional contact with the listed victim.
No se le permite tener ningún tipo de contacto y comunicación intencional con la víctima que aparece nombrada en el informe.
This means directly, indirectly, or through a third party.
Esto significa que el contacto y la comunicación no pueden ser ni directa, ni indirectamente, ni a través de terceras personas.
You must stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school.
Usted tiene que permanecer alejado de él por lo menos 500 pies de distancia, del hogar de él, de sus vehículos, donde él trabaja y donde él vaya a la escuela.
Anything else we need to do, Mr. Ledner?
No, sir. His daughter will be the one that picks him up. I told her I'd call her after court, so I'll explain everything you just explained to him, and she'll make sure that he gets it done tomorrow.
¿Alguna
Thank you,
otra
Judge.
cosa más que necesita usted de mí, señor Lerner? No, la hija de él va a ser la persona que lo va a ir a recoger. Yo le dije a ella que la llamaría después de la audiencia de hoy. Le explicaré todo como usted le acaba de explicar a él para asegurarme que ella se lo explique y que haga todo mañana. Muchas gracias, juez.
Next up is Maria Jesus Murillo León.
María Jesús Mario León.
Ma'am, you're here having been arrested for grand theft related to a shoplifting allegation.
Y señora, usted se encuentra aquí hoy porque fue arrestada por un cargo de hurto mayor relacionado con un alegato de robo en tiendas.
You want me to appoint the public defender, or are you going to hire a lawyer that you choose?
¿Usted quiere que yo le asigne, le nombre un abogado de oficio o va usted a contratar a su propio abogado?
Lo voy a contratar.
I'm going to hire one.
All right, ma'am. I reviewed the paperwork and I find probable cause for the charge.
Muy bien, señora. Yo he revisado los documentos y encuentro motivo fundado para el cargo,
Recognizing that you don't have any ties to Polk County, but instead live in another county.
y reconociendo que usted no tiene ningún tipo de enlace o conexión con el condado de Polk, pero que en lugar de eso usted vive en otro condado,
I'm going to set your bond at $7,500.
voy a fijar su fianza en $7,500
Make that bond a condition of pretrial release.
y hacer que esa fianza sea una condición de su libertad condicional.
If you post bond, you must immediately check in with the Office of Pretrial Release Services.
Si usted deposita la fianza, inmediatamente debe presentarse en la oficina de servicios de libertad condicional.
Call them on Tuesdays and Thursdays while your case is pending.
Llamarles los martes y los jueves mientras que su caso sigue pendiente en el sistema.
You have all the standard conditions plus the following special conditions.
Usted tendrá todas las condiciones estándares más las siguientes condiciones especiales.
You're not allowed to have any intentional contact with the listed victim. In this case, it's Target.
No se le permite tener ningún tipo de contacto intencional con la víctima nombrada en el reporte. En este caso es Target.
Entiendo.
You're not allowed to have any intentional contact with any Target retail establishment.
No se le permite a usted tener ningún tipo de contacto con ninguna tienda de venta del nombre Target.
Step to your left, ma'am.
Pase a su izquierda, señora.
Ms. Hernandez, I think that's everybody I've been made aware of.
Okay.
I
Make
believe
an
we-
announcement.
I believe we have one more here at Central. Olguin, Olguin.
Right, Ignacio Olguin Mendoza is here on 3 charges.
Él se encuentra aquí, el señor, con 3 cargos.
Charged with no valid driver's license, DUI with a breath greater than .15,
Tiene un cargo de manejar sin licencia y un cargo de manejar bajo los efectos con una lectura en el alcoholímetro mayor que .15.
as well as driving under the influence with property damage or injury to another.
Así como también manejar bajo los efectos con daños a propiedad o lesiones a otro.
All of these charges have been upgraded 1 degree based upon your illegal status in this country.
Todos estos cargos han sido aumentados un grado más, basándose en su estatus ilegal en este país.
You want me to appoint the public defender, or are you going to hire a lawyer that you choose?
Señor, ¿necesita que yo le nombre un abogado público o va usted a contratar un abogado que usted elija?
Abogado público.
A public defender.
I'll appoint that office.
Voy a nombrar esa oficina.
After reviewing the paperwork, I find probable cause for the 3 charges.
Después de revisar los documentos, encuentro motivo fundado para los 3 cargos.
Your bond on the DUI with property damage is $2,000.
Su fianza por el cargo de manejar bajo los efectos con daños a la propiedad es $2,000.
Your bond on the DUI with a .15 or higher is $2,000.
La fianza en el cargo de manejar bajo los efectos con una lectura del alcoholímetro mayor que .15 es $2,000.
And your bond for driving without a driver's license is $1,000.
Y su fianza por manejar sin licencia de conducir es $1,000.
Step to your left, sir.
Hacia su izquierda, señor.
Because you have a ICE hold, I am going to ask the clerks to prepare a detainer for my signature. Have a great day.
Como usted tiene una orden de retención de ICE, voy a pedirle a las escribanas que prepare una orden para mi firma. Tenga buen día, señor.
Ms. Hernandez, I think that's it. Have a great rest of your Monday.
You too, Your Honor. Thank you.
All right, let's call up Sanchez Viruet. Looks like it's Emmanuel Sanchez Viruet.
Yes, sir. ASA Joe Stan with the state.
Good afternoon, Mr. Spano and Mr. McKendrick. As far as the charges, waiving the charges, you okay with me reading them?
I'm okay with you waiving the charge.
Okay,
There's just one charge.
Right.
Correct.
sure. Yeah, just one count.
And before we start, I know that there was an amended probable cause affidavit. Is the court, does the court have that in its possession?
I can certainly tell you what I've reviewed. Give me 1 second to pull it up. Sometimes it, unlike informations, it doesn't label it
Of course.
as an amended. So unless I was aware there was an earlier one, I might not know it's an amended.
And I have a copy as well if needed.
It would say amended affidavit, Your Honor.
But you're on that second page right there?
Correct.
Yeah, I've reviewed, the one that I reviewed was the amended.
Okay, thank you.
And you're right, this one jumped off that jumps off the page at me, but sometimes if it's not there, I would not know. All right, so yes, I have reviewed that one. So sir, you're here having been charged with 1 second-degree felony. Second-degree felonies are punishable up to 15 years in prison. Mr. McKendrick's here on your behalf. He may be retained for the whole case. If for some reason he's not, you always have a right to ask for a public defender at any time your case is moving through the system. Have you reviewed the affidavit and any probable cause challenges?
I have, and I was here Saturday, Sunday, and today.
Okay, I didn't know that until you just told me that.
And I think that's why it was amended to the second part, which is the second page about the 2 male students. The first page, there's no probable cause.
I was gonna say, could you just a bit for my benefit, not knowing, I show up on Monday and I'm told this is how many first appearances you have, Judge, and I read them and I work off this list and it doesn't say they were here, Friday, Saturday and Sunday.
That's right.
You can just give me historical how we got here from.
Yeah, so Saturday I was here, he was arrested Friday. Didn't have him ready for Saturday, so I showed up yesterday. Yesterday, with the probable cause affidavit was just the first page, which ended up at the bottom where the first page is here. And so I objected because the probable cause on that one just alleged that my client had touched somebody's thigh. And that was not something that was leading to serious. So the court continued it till today, until this afternoon. Now we have the amended, which has the other allegations on the second page. There are contradictory statements on the second page. There were 2 male students. The one says he touched the front of his thigh and back of his thigh underneath his buttocks, which is not leading to serious. The other one said, and there's 2 different ways. There's screenings that they talked about on that second page. So the one young man said that the first paragraph, front of his thigh and back of his thigh. The second one said that he just solicited him for sexual intercourse. And then if you go 2 paragraphs down, it does say that the first male in the first paragraph on the top of that page said that he touched the clothing in the area of his penis and buttocks. That's not really, and I understand that lewd lascivious is buttocks, genitalia, or genitalia area, but I think in conjunction with the very first paragraph, front of his thigh and back of his thigh, that doesn't, it's a probable cause issue. The last one said when he was interviewed, and that's Diego says that he just grabbed him by his wrist and rubbed up against his shoulder. So I do have a probable cause issue with this, Your Honor. I don't think it's, I'm not saying that any of the alleged conduct is good. I'm just saying that for the affidavit as it is with the lewd lascivious, I would have to contend with that.
Say that last part again.
I would have to contend with that being part of it. So,
Yeah, I'm just pulling out the statute.
yes.
Certainly, these get pretty specific as to the comments.
Yes,
So
so it's 800.04. Says 6C.
I might be able to provide some guidance before.
sure, yeah, why don't, Mr. Spano, hold tight. Like I said, you're going to have as much time as you want. I just want to, now that I've heard that there's a history to it and that we have where it stands now, it looks like the alleged victim is the victim from the front page, but yet there's a lot of discussions about
Correct.
gentlemen.
Because there's just the one charge.
Right. So that makes it a little more hairy. So let me just read 800.046B momentarily. Anything else? If not, let Mr. Spano. Mr. Spano, go right ahead, sir. I got the statute right in front of me for reference if you want to cite anything.
Of course. So first and foremost, I respectfully disagree with Mr. McKendrick. The charges that the defendant was charged with do not require a specific area of the victim to be touched. The charge itself just indicates whether or not a person was touched in a lewd or lascivious manner. But when we look at the specialized jury instructions or the standard jury instructions in this case, lewd and lascivious mean the same thing. It's a wicked, lustful, unchaste, licentious, or sensual intent on the part of the person doing the act. I think the confusion was when the defendant was first brought here. I believe the original judge who was determining probable cause believed that there was supposed to be a certain area that needed to be touched. That's for a battery, not for the conduct in which he was charged with. When we looked at the probable cause affidavit, at least the facts that are alleged and they're sworn to, when the defendant had touched the victim and put his hand and rubbed her thigh, telling she was beautiful, had nice eyes, and he liked her body. Also a comment that he made to her about him having a sexy voice to her, I do believe is enough to show that the defendant did in fact touch the victim in a lewd or lascivious manner, which is all that is required by the statute. And we are also going to be filing a motion for pretrial detention on this defendant as well. And I have a copy of that motion if the court allow me to approach.
Sure.
Well, thank you.
So this gentleman is already on pretrial detention for other charges?
I don't believe so. This is only arrest. So when I look at
So motion, I see what you're saying. You're saying a motion for pretrial detention as in
for this, right? Yes, we want to file that.
you're not I jumped ahead. You're not revoking pretrial. You're just trying to have him held, no bond pursuant to Florida Rule of Criminal Procedure 3.132 and Florida Statute 907.0415C5.
That is because, yes, that is because the charge the defendant is charged with is an enumerated dangerous felony, and pursuant to that rule, in which the state's request, the court can hold him no bond pending the hearing on that motion that was just filed.
Mr. McKendrick, any thoughts on their argument that it doesn't have to be a specific body part, it just has to be done in a lewd, lascivious manner? That does appear to be what the statute says.
I'm looking at the statute, Your Honor. I'm looking at 804.6C. Can you, if they don't mind saying where exactly it says that in 6C?
Showing Mr. McKendrick a copy of it right now, just with the subsection 6, lewd lascivious conduct, subsection A1 intentionally touches a person under 16 years of age in a lewd lascivious manner. That whole subsection 6 does not require any type of body part to be touched. And also I'm showing opposing counsel as well, a copy of the standard jury instructions that indicates the same, that no required location of the body needs to be touched.
Okay. Well, under 4, losing the city's battery, it's, it requires sexual activity. I believe it does. I believe that does require touching in certain areas, Your Honor. And that's why I raised the probable cause affidavit. The thigh is not a sexual organ. It's not near the sexual organ, and that's what's alleged here.
It's not, Your Honor.
So those are the issues that I have, especially with the allegation made here is that he only touched this person's thigh, and that does not losing lascivious.
You got any case law or any authority that says that supports the argument you're making?
This is brand new, Your Honor. I got it yesterday for the first time, and I've seen it amended today, so I can certainly come back if I need to.
Can I see that jury instruction?
Yes, Your Honor.
I don't have that.
And
You said bring my West publication if I thought I was.
It's 1110B.
Okay.
Even Delta.
Yeah, and just keep being mindful, charged with lewd and lascivious conduct, not lewd and lascivious battery.
Correct.
Okay, and that's a big distinction. Reading over. Mr. McKendrick, I'm agreeing with Mr. Spano on this one. I think there is probable cause. So I am going to find probable cause. Now, normally I would ask you about arguments as to bonds, but in this case, there is a motion for pretrial detention. And for the record, it's a 1, 2, 3-page document signed by ASA Matthews. I have reviewed this. I see that it cites to Florida Rule of Criminal Procedure 3.132 and Florida Statute 907.0415C5. I do find that it's legally sufficient. And as a result, I think I had no choice, having found it legally sufficient, but to hold him no bond and send him to see the circuit judge, the A2 judge, at the appropriate date that this Monday first appearance should go to. And that would be.
Yes, Your Honor. State would request that hearing be held on Monday, March 16th at 1 p.m. on the A2 docket.
I will be out of town on the 16th, Your Honor. Can we set it for the following Monday?
Sure. I mean, I know they do it, and it's twice a week.
Could it be later this week?
I know that it's a twice a week thing, and I have without, I know depending on the date that they come to first appearances, it dictates it.
Yes,
I believe it was being done today. Is that
That's
A2
correct.
documents today, and then they normally do it on Mondays and what, Thursdays?
Yes, Your Honor. So the schedule that we were given for motions filed Monday through Thursday, we set it for the following Monday, and then everything motions are filed Friday, Saturday, or Sunday, except for the following Thursday.
Any reason, and again, because he's been back 3 times and he's been in jail a couple of days,
Yes,
if
sir.
you guys don't kick and scratch and scream about it, I think Thursday would be appropriate. I mean, because he's not available until the following Monday. And this came through first appearance, she said over the weekend, which otherwise had the judge over the weekend done what I'm doing, you would have got Thursday. But it got pushed to Monday because of the amendment. And now that would push you to next Monday, which you can't be here to push you to 2 weeks. I think that a Thursday, in light of everything, would be appropriate. Anybody have any objection to that?
Full candor for the court, Your Honor. I don't know what the officer availability is like for this coming Thursday. We can certainly look into that.
Well, I mean, I think it's the kind of thing that candidly, if you find out that the officer's not available, y'all could certainly bring it to that judge's attention. Hey, Judge Stamey thought it was appropriate for Thursday because we knew it was a compressed time, but we did that because it came in over the weekend. Mr. McKendrick's not available next Monday. I would like to think that everybody could find another date that they could all agree on, but let's set it for Thursday. Okay, I think that's probably proper to do in light of everything I've heard.
Thank you.
Yeah, so I'm going to hold him no bond. We're going to send him in front of the A2 judge for this Thursday, the 12th at 1 p.m. And then I'm going to hand this to the clerk so that the judge on Thursday can certainly have the report file.
Thank you very much.
You bet. Have a great day. Is that everything from you, Mr. Spano?
Maybe excused.
You bet. Have a great day.
Next one, thank you.
You want, I did give you your jury instructions back, did I not?
You did.
Good, thank you so much. All right. You ready to call yours up?
Order, Your Honor.
Good
Afternoon.
afternoon, yes.
Paul Watson, VOTSIS.
Approaching.
VOTSIS. D.
V is in Victor.
Sir, you're here having been held on charges of domestic battery and domestic violence assault. And you're going to be here representing him. He's not just a limited appearance, you're representing him.
Correct, Your Honor.
All right. So you already have an attorney and any probable cause challenges on Mr. Vatsis?
The only thing I'd like to bring to the court's attention is that it looks like this is a singular incident. And to charge the assault and a battery, it's almost like you're getting hit with a lesser included offense at the scene. That's my only challenge. There is some verbiage in there that says there is a fear of punching, but it does look to be at the same time or during the same incident.
Nakagao, what's your thoughts on that?
Your Honor, in reviewing the affidavit, it does seem like this was one.
Temporal break, right?
Yes, Your Honor. This is what I hope.
Can I add something if I want to later?
All right, sir, I'm going to find probable cause for domestic violence battery. I'll find no probable cause, being that it's somewhat of a lesser included, subsumed into the higher offense. The assault will be no PC ROR on that one. I'm going to set your bond at $5,000 on the domestic battery. I'm going to make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them daily. The reason I'm doing daily, sir, is one of your conditions is going to be GPS, and I'm doing that based upon the death threat. You're going to be on pretrial release with the daily call-in, all the standard conditions plus special conditions, 16, 17, 18, which is no weapons or firearms or ammunition can be possessed, no intentional contact with the listed victim, stay 500 feet away from her home or vehicles, where she works or where she goes to school. You get to return to that home one time that you shared with her within 48 hours of your release from custody with the police to retrieve essentials like medicine and clothing. And I'm going to instruct that if you post that bond, that you'll be held by the Polk County Jail until such time you've been outfitted, equipped with a GPS monitor. That's the best way I can ensure that you stay away from her, because we'll have 24/7 reporting. I'm not saying you have to be confined to your home. I'm not doing house arrest, but I just really mean it when I say stay away from her. And again, I base that on the allegation of a death threat. So anything else?
Nothing additional.
Good to see you. Have a great day, sir.
Thank you, Judge.
Sir, can I add something if possible?
Sir, I would advise you not to speak or not to make any
Okay.
statements
I appreciate it. Thank you.
as soon as you get out or tomorrow if you're still incarcerated. Okay.
And certainly anything I do today, a judge assigned to your case can go behind me and change it. So that's just, well, this is, in this posture, I thought it was appropriate. Have a great day. Thank you.
Thank you.
All right, everybody, we're going to start with the gentleman in South County, do the ladies, and then finish up with the men in the back. First up, we have Gabriel Diaz Jimenez. Sir, you're being held on 3 charges. They are domestic violence ag assault, domestic violence battery, and domestic violence false imprisonment. Do you want the public defender?
Yes.
I'll appoint them. I've looked over your paperwork, finding probable cause, setting your bond at $5,000 on the domestic violence ag assault, $5,000 on the domestic battery, and $5,000 on the false imprisonment. Each of those bonds is going to be a condition of pretrial release. If you're able to post those bonds, you must immediately check in with the Office of Pretrial Release. Call that office daily. All the standard conditions and special conditions, 16, which says no weapons, firearms, or ammunition can be possessed. No intentional contact with the alleged victim is 17. You have to stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. And since you resided in the same home prior to your arrest, You get to go there one time with the police within 48 hours of getting out of jail to get your essentials like medicine and clothing. Like the last gentleman, I'm going to order that if you're able to post those bonds, you'll be held in the jail until you have been equipped with a GPS monitor. I really want you to have no contact with the alleged victim. The best way I can ensure that happens is to put you on a GPS monitor. It's not house arrest, so you get to go about your business. You just can't go within 500 feet of the victim, their home, their vehicles, where they work or where they go to school. Have a great day, sir. Next up is Francisco Javier Esparza Jr. Sir, you being held on one charge of domestic battery. I find probable cause. Go right ahead, Ms. Smith.
Yes, Your Honor. I read the police report says he has a prior, it just is a prior history of a domestic battery charge for Illinois, but he wasn't convicted. So he was either dropped or, but anyway, he has no conviction for any batteries. I don't know that he has any other history in Illinois, but he does no history in Florida. And it says that, and he of course denies that he got physical with the alleged victim. And she said that I believe that he grabbed her right arm and pushed her. So I was going to ask if we could have a low bond on this charge, assuming he has no other record in Illinois.
Anything from the state?
I would remember that just because he was never convicted, it's possible maybe he would hold into the court again. I don't know. I didn't get any further information regarding any prior history from Illinois. I'm requesting standard bonds in this case.
Yeah, it looks like there was something out of Payne County, Illinois that was no prost.
Okay,
Best
so
I
all he
can
has is one no boss. It's
Looks like it all looks the same thing.
Okay.
Yeah. All right, sir. Having found probable cause, I'm going to set your bond at $2,500, making it a condition of pretrial release. If you post that bond, report it into pretrial services, sign up with them, calling them on Mondays. You have all the standard conditions, plus special conditions. For your case, based upon what I've read, I'm going to require that you not be in possession of or consume any alcohol. You can't go to bars, nightclubs, or lounges. You'll be subject to random breath testing at your expense. You also have condition 16, which says you can't carry or possess firearms, weapons, or ammunition. 17, which says you can't have any intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. And I will allow you also to return to that home one time that you shared with the victim within 48 hours of your release with the police to retrieve essentials like medicine and clothing. Have a great day, sir.
got to write down. Were we appointed?
Sir, do you want the public defender on your case?
Yes, Your Honor.
I'll appoint him.
Thank you.
Can I make a comment though? She no longer lives at that residence.
Sir, if she doesn't live there and she's vacated, my goal is not to make that place set empty, but you'll just have to kind of find a way to confirm that with pretrial. And if it's confirmed to them that she's left the location, you can certainly go back.
She left a
You
week
just have
ago.
to stay 500 feet away wherever she's living now. You just
Of
got to
course,
stay
of
500
course.
feet away from that.
Because I work from home, that's the other problem, so.
All right, sir. So if she's moved on, you get to move back.
She's moved on. Yeah,
That's to
she's moved
confirm.
on. Yeah.
Have a great day, sir. Tony
Thank you.
Fender? Mr. Fender, you're being held on domestic violence battery. Do you want me to appoint the public defender?
Yes.
I'll appoint them. Sir, I've looked over your paperwork, finding probable cause, setting your bond at $2,500, making it a condition of pretrial release. You post bond, you must check in with pretrial, sign up in person, call them on Mondays. All the standard conditions as well as 16 and 17. 16 says you can't use, possess, or carry firearms, weapons, or ammunition. 17 says you can't have any contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Have a great day. Timothy Harrison? Sir, you're being held on 3 charges. They are possession of cannabis, possession of paraphernalia, possession of methamphetamine. Do you want the public defender?
Yes, sir.
I'll appoint them to represent you.
Can I be pre-trial? I'm a
sir,
chronic diabetic.
I take note that you have an open case, 26 MM 1399. So what I'm going to do is appoint the public defender. I reviewed the paperwork, finding probable cause. Because you have an open case and you picked up these charges, I'm going to bump your bonds up a little bit. It'll be $6,000 on the methamphetamine, $2,000 on the paraphernalia, $2,000 on the cannabis, and I am going to revoke your bond on the case of 26 MM 1399. Hold you no bond pursuant to the authority of Parker versus State, and appoint the public defender on that misdemeanor if they weren't already appointed. Have a great day, sir.
So can't it be pre-trial?
No, sir, you're being held no bond because you picked up new, more serious charges while on probation for the same type of charges. On bond for the same type of charges. Have a great day, sir. Next up is Kyle Knapp. Does he have priors? Mr. Knapp, you're being held on one charge of battery. You want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you. DUI in 21. Okay. Sir, I'll appoint the public defender. I've looked over your history. You have, it looks like a prior DUI a few years ago. Having found probable cause for this charge, I'm going to straight pretrial release you.
Thank you.
You're welcome. That means if you're able to post that bond, you must immediately check in with pretrial release, sign up in person, calling them on Mondays. You have all the standard conditions of pretrial plus the following special conditions. Yes, sir. I'm glad I jogged my memory. I glanced at the affidavit. Yeah, so you'll be getting out of jail. You have to sign up with pretrial. You probably won't make it there today, so you got to go tomorrow. You have all the standard conditions plus the following special conditions. I don't have the ability to tell the victim to get out of that house. That I'm not an eviction judge today. My role is a criminal judge. So you'll be on pretrial, which means while on pretrial, you can't have any weapons, firearms, ammunition, or knives in your possession. And I don't know if the alleged victim is there or has moved somewhere else, but you're going to have to find, if he's moved out, you get to go back. If he's still there, you have to find somewhere else to go to because you're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works or where he goes to school. Okay. Have a great day, sir.
Okay.
Yeah, you can give him one time to go back, number 18. So, sir, you get to go back one time if you want to get your stuff, if he is still there. That brings us to, we've done Mr. Sanchez Viruet, so we're up to Charles Sutherland. Mr. Sutherland's being held on 3 charges. They are corruption by threat, DV battery, and DV simple assault. Sir, do you want the public defender appointed to represent you?
Yes, sir.
I'll appoint them to represent you. Ms. Smith, you want to be heard on PC or bonds?
Bond.
Okay. Sir, I have looked over your paperwork back in my office, brought the big old stack of things I've read with me. I find probable cause for these 3 charges. Ms. Smith, how would you like to be heard?
Your Honor, I looked him up. Again, I had to do this myself, but I looked his name up in CCIS and his date of birth, and I didn't see any prior charges other than this. And I don't have access to out of state, so I don't know if he has an out of state history. But assuming if this is his first charges ever, I would ask for lower bonds on this.
Yeah, he does have, apparently, Ms. Smith, it does look like, and he is the defendant, yeah, Charles Sutherland. Okay. It looks like he had a felony case in 22 that had a lot of, looks like he was arrested for about 10 charges. There was a lot of no action, so it looks like the state whittled it down. Once they whittled it down, it looks like he was found guilty of an assault. And then there's an adjudication withheld on the resisting with violence.
What state is that?
Looks like it's Florida, 22 CF.
Does he have a different name or date of birth? Because again, I just put the date of birth that I have on the docket and the name.
That's what we do too.
I didn't see anything.
Yeah, it's a 22, if you want to double check.
That's fine. I'll just defer to the court. I may have put the number in wrong or something, but yeah, I do it myself.
And you know, it looks like, just so you know, corruption by threat, 1, 2, 3, 4, 5, 6 counts. The state just no action to all of them. They no action to criminal mischief and a resisting without. They pursued the assault and a resisting with violence. And he got the withhold on the felony and the adjudication on the misdemeanor. And unfortunately, it looks like these charges he's here for have a similar flavor: corruption by threat, domestic battery, and simple assault. So, sir, if I didn't ask, and I think I did, you want the public defender? I appointed them. I've looked over the paperwork. I find probable cause. I'm going to set your bond at $5,000 on the corruption by threat, $5,000 on the domestic battery, and $2,500 on the DV simple assault. I'm going to make those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial release services, calling them on Tuesdays and Thursdays. You have all the standard conditions everyone else has, plus special conditions 13, which says you can't possess or consume alcohol. You can't go to bars, nightclubs, or lounges. You'll be subject to random breath testing at your expense. You're not allowed to carry weapons, firearms, or ammunition. You're not allowed to have any intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. And because you resided with the victim in that home prior to being arrested, you get to go back one time with the police within 48 hours of getting out of jail to get your stuff, like medicine and clothing. Have a great day, sir. You bet. Terrence Tabor. Sir, you're being held on one charge of aggravated battery. You want me to appoint the public defender?
Yes, sir.
I'll appoint the public defender. I've looked over the capias as well as the information, finding probable cause, setting your bond at $15,000, which is a standard bond for an aggravated battery, which is punishable up to 15 years in prison. So with a $15,000 bond, it'll be a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, call them on Tuesdays and Thursdays. All the standard conditions plus special conditions 16 and 17, which says you can't possess weapons, firearms, or ammunition, and you can't have any intentional contact with a listed victim. That means directly, indirectly, or through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. Have a great day, sir. Deputy, that's all that I had that I showed for South County. Do you have some extras?
Yeah, we got a number from bookend, Breon Causey, Causey.
All right, Breon Causey. Hold tight, Ms. Smith, 1 second. I'll let Ms. Causey, Mr. Causey, you're charged with burglary with an assault or battery. As far as the next two, are you?
Yes, I wanted to waive the reading of the 2/3.
All right. You got it. So, sir, 3 charges: burglary with an assault or battery, and 2 F3s. That the reading has been waived. Do you want the public defender?
Yes, sir.
Appoint that office. Sir, I've looked over the paperwork that I've been provided, and I find probable cause. Would the state like to be heard as it relates to bonds?
Yes, Your Honor, regarding the burglary with an assault or battery, I said it is a first-degree felony punishable by life. State if you're requesting the defendant be held to a bond.
I'm not inclined to do it on this one. If you're wanting, if this is eligible for
It is, Your Honor.
a pretrial.
Request 24 hours.
Yeah, like I said, I want to just be upfront with you. I've reviewed it. I thought, I put this in the category of one that I would not do if I was using my discretion, but certainly if I was here and you filed your motion that I found legally sufficient, I would follow the law. So if you want me to do that, I can.
Yes, Your Honor, I would say would request that this be brought back tomorrow for a motion to be filed.
Only on the burglary, or can we go ahead and handle the F3s now?
We can go with the F3s now, Your Honor.
Ms. Smith, you okay with that?
Yes.
Okay. Mr. Causey, I find probable cause for all 3 charges. On the 2 F3s, I'm going to set your bond at $5,000. The state has requested that I bring you back tomorrow to give them time to potentially file a motion for pretrial detention on the burglary with an assault or battery. I'm going to do just that because I think that's what the law tells me I'm supposed to do. So I'm going to bring you back tomorrow only on that charge. But on the 2 F3s, your bonds are $5,000. Those bonds are going to be conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial release, sign up in person and call them on Tuesdays and Thursdays. All the standard conditions plus special conditions 16, 17. I'd also do 22. As far as to state any other that you're asking other than the 22. All right, sir. So those are your two. Set your bond on the two F3s. You're coming back tomorrow to see a judge on that burglary within a battery. Have a great day.
Cheers, Will.
Then we skipped over Jacob Mack.
But it's kind of fun because there's any hell in on. All right. Take a look at Mr. Mack. Yeah, you're absolutely right. I just overlooked him when I was doing Mr. Knapp. Jacob Mack is charged with petty theft. It's a first degree with an allegation that theft was greater than 100 but less than 750. Mr. Mack, do you want the public defender?
Yes, please.
All right, I'll appoint that office to represent you. Sir, I've read your affidavit and I do find probable cause for this particular charge. I also take note that you don't live in Polk County. You live in the county quite a ways away from Polk County. Looks like you might have just been passing through with no ties to the area. So having found probable cause, with that being the case, I'm going to set your bond at $2,000 cash or surety. Have a great day. Thank you, Deputy.
Yes, sir.
All right, moving on to the ladies. Jawan Alo. Ma'am, you're being held on two charges: domestic violence assault and domestic violence battery by strangulation. The battery by strangulation is a felony, punishable up to 5 years in prison. Do you want the public defender?
Yes, please.
Appoint the public defender. I review the affidavit. I find probable cause for these charges. Go right ahead, Ms. Smith.
I don't see, again, any prior record for the date of birth that I had for her and her name in Florida. Assuming if you didn't have any prior record, I would just ask the court to look at this for bond purposes, the lack of prior record. Double check that other guy, get another date of birth that I didn't check.
Looks like the pretrial agrees with you. There's no known record. So let me just pull her facts up again. Pretrial tried to reach the victim but was unsuccessful. So I agree, no prior record. So make what were you asking, just for a lesser bond?
Yes, to defer the court. I don't know if he's eligible for straight pre-release.
Same with the judge, straight files, right?
Yeah, I'm not saying I would never do it on a domestic F3, but don't feel real comfortable doing it on one where someone's alleged to have restricted the air.
Yes, sir.
So, ma'am, having found probable cause, what I'm going to do is set your bond at $2,500 on the simple assault, and I'll set it at a similar $2,500 on the domestic battery. So it's $5,000 total. If you're able to post those bonds, you must immediately check in with pretrial release services, sign up in person, and call them on Mondays. All the standard conditions plus special conditions 16, 17, 18, which says you can't have any weapons, firearms, or ammunition in your possession while on pretrial release. You also can't have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicle, where he works, where he goes to school. And since you lived with him prior to being arrested, you get to go to that home one time within 48 hours of getting out of jail with the police if you choose to, or essentials like medicine and clothing. Have a nice day, ma'am. Next up is Nicole Ranchetta.
I just want to be her regarding one.
Sure, who's charged with domestic violence battery. Ma'am, do you want the public defender?
Yes, please.
Ma'am, I'll appoint the public defender. I've looked over the paperwork and I find probable cause for this charge. Go right ahead, Ms. Smith.
And I didn't see any prior record for her release in Florida. I was gonna ask if she could be straight free for release or have a lower bond and an alternative.
You show no, I see it right there, no record. And how old is she? She's okay. Ma'am, having found probable cause, certainly looking at that you appear to be a law-abiding citizen, haven't been arrested before. You have not been recommended for straight pretrial release. And that is that based upon the victim, I haven't had contact with the victim, and is that the primary reason? Ma'am, I tell you what, if I let you out of jail without posting any money and tell you to have no contact with the alleged victim, you gonna be able to follow that rule and any other conditions I put on you?
Yes, sir.
And I understand, I've read the affidavit. I understand that tensions can run high.
Yes.
Sometimes we got to be able to control ourselves, you know, I wasn't there. I don't know what happened. I don't know if you're guilty, not guilty, what I'm just saying, just as an aside, people got to learn how to control their tempers and sometimes be composed. So what I'm going to do is if you promise me you're going to show up to court when you're supposed to, I'm going to let you out of jail
Yes,
with
sir.
no bond, without posting a bond, should I say.
Thank you,
So
sir.
Welcome. Before you thank me too fast, just know that I got to do one more thing because the law requires it. Hold tight. I'm going to let you out of jail without posting a bond, put you on pretrial release. That means you're probably going to get out of jail after 5 o'clock today, so you won't make it today. They'll close at business closing time. So you got to go tomorrow and to pretrial release services. It's here in Bartow over on Highway 17. Sign up in person, calling them on Mondays. Every Monday while your case is still pending, you got to call and just check in. You have all the standard conditions everybody else has who's on pretrial release, plus the following special conditions. You're not allowed to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're also prohibited from having any intentional contact with the alleged victim. This means directly, indirectly, or through a third party. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. Now, I know you don't live together, so I'm not letting you go to his place or, to get your stuff. You don't live with each other. The one thing I was going to say, by law, I have no choice. They may already know because the police have the same duty I do. Since this allegation is that there was a battery that occurred in the presence of a minor child, the law says I have no choice. I have to notify DCF. So I just want to let you know that that's what I'll be doing. Again, they may already know because the police have to report it too, because it took place in the presence of, not against the child, but the child was present. I have to report it. Okay. Have a nice day, ma'am.
Thank you.
That brings us to Sabrina Gechter. Ms. Gechter, you're charged with domestic battery. You want me to appoint the public defender?
Yes, please.
Appoint them. I've looked over your paperwork. I find probable cause. Go right ahead, Ms. Smith.
I didn't see any prior record for her, at least in Florida. She has no prior record. It looks like she just pushed him against in the chest with 2 open palms. He fell, but he hit his head. But all she did was a push. So I was going to ask her if she could be straight free for release if she has no record.
No contact with the victim. Yeah. Yeah. I mean, it's. Ma'am, I can tell that you're, appear to be a law-abiding citizen since you didn't turn 18 last week. You had a decade or more as an adult. You don't have any record. So what I'm going to do is I'm going to straight pretrial release you. So if you're able to post that bond, you'll be getting out of jail today without posting any bond. You won't make it today, so you have to do it tomorrow. report into pretrial release services here in Bartow. You have all the standard conditions that everyone else has, plus the following special condition. You're not allowed to use, possess, or carry firearms, guns, weapons, ammunition, or knives. Just so you know, pretrial release, Miss Amber here works for them, and her office tries to call the victim of every domestic before I come to see you at first appearances. They tried, they were unsuccessful. Had they been successful and talked to the alleged victim, they would have asked some questions like, hey, do you want her to come home? Do you care if you have contact with her? I don't know what his position would be. I just didn't get any feedback. So as a result of that, your special conditions are 16, 17, and 18. You've heard them several times already. You can't have weapons, firearms, or ammunition in your possession. You can have no intentional contact with the victim, as well as his home, his vehicles, where he works, or where he goes to school. Stay 500 feet away from all those places. And because you lived with him before you got arrested, you get to go back there one time with the police to get your stuff. Have a great day.
Thank you.
Amy Harrington. Ms. Harrington is being held on 2 charges, battery and trespass. Ma'am, do you want the public defender?
Yes, sir.
I'll appoint him. Looked over the paperwork, finding probable cause. Your bond is $1,000 per count. Have a great day, ma'am. No, just straight 1,000 on each of those. It wasn't domestic. Jessica Milton. Milton, you're being held for, well, it looks like you failed to appear for drug court, PADC. Ms. Smith, not a VOP, so no, it's just an FTA from drug court. So ma'am, Ms. Smith and I agree that you're not eligible for an attorney because you're not facing a VOP that we're aware of, just Miss Court. So I'm going to find probable cause, going to hold you no bond. The good news for you is they do drug court every week. So you're going to go see Judge Pinkett in next week. Is that right? The 17th? So it'll be next Wednesday.
Wouldn't it be tomorrow?
They're not doing morning docket.
You're not doing KBC tomorrow? Oh, so she has to wait a week.
Right.
Okay, are they not doing it on Tuesday?
No, it's just something with the judge.
Okay.
Or she doesn't have a morning docket.
All right.
So you got to go see her next Tuesday. Have a great day, ma'am. Jessica Mrose. Ma'am, you're being held on 3 things. They are possession of meth, possession of drug paraphernalia, giving false ID to a policeman. Do you want me to appoint the public defender?
Yes.
Appoint that office. I've looked over your paperwork, finding probable cause, also realizing you have a VOP out of California. California VOP. So I'm going to take that into account when I set your bond.
It's not expeditable.
And that still don't mean it's still not a good thing that you're leaving it hanging out there. I'm not saying we're sending you back to California. I'm just saying I don't want the next time you see a judge in Arizona for him to say, oh, you got a bond in Florida, but it's not extraditable. So with all those things being considered, I'm going to bump your bonds up. So on the possession of meth, it's $7,500. On the paraphernalia, it's $2,500. And on the false ID, it's $2,000. Have a great day, ma'am.
Thank you.
Next up is Michelle Myers. Does she have prior record? Ms. Myers, you're being held on a petty theft charge. You want the public defender?
Yes, sir.
All right. That's her local charge, DUI and knowingly driving my license suspended. Nothing else. So I'll appoint the public defender. Find probable cause for the charge. Going to set your bond at $250. Have a great day. Andrea Rivadeneira. Ma'am, you're charged with interfering with a first responder, resisting an officer without violence, and battery on a law enforcement officer. You want the public defender?
I'm gonna get my own.
Okay. You certainly have that right to do that, but if you change your mind, you can always ask for a public defender at any time moving forward. Ms. Smith, you want to argue PC or bonds? I haven't said it yet, but I did review it, yeah. So ma'am, I have reviewed your affidavit back in my office. For my review of that document, I find probable cause. Ms. Smith, you want to be heard on bonds?
Yes, I didn't see any prior record, for her name, or does she have something?
Yeah, let's see what it is.
And she had different, on the docket, it's a Riva Genera, but on the actual affidavit, it's Molina dash Riva Genera.
Yeah, it looks like there was some 22, it was no prost, it was
Oh,
a fray, so.
well, if that's all she had, that's if she could have reduced bonds.
I stick with bonds in this case, Your Honor.
I think this is, going off of memory, was this the one where apparently she just grabbed the police officer's arm?
Yes, this is the grabbing of the arm thing.
Yeah.
Yes, that was it.
Yeah. Her date of birth is, make sure she's born in 95. So yeah. So for born in 95, looks like you're about to turn 31. So you've been an adult for some time, appear to be a law-abiding citizen. So ma'am, what I'm going to do is, having found probable cause, I'm going to set your bond at 250 on the interference with a first responder. I'm going to set your bond at 1,000 for the resisting, but I am going to reduce it on the battery on a law enforcement officer. I'll set that at 2,500. Have a nice day, ma'am.
Thank you.
Elizabeth Roberta Scott.
Scotty.
I'm sorry, Scotty, my apologies.
That's okay.
Miss Scotty, you're charged with domestic violence battery. Are you planning on hiring a lawyer or do you want the public defender?
Public defender for now.
Sure, I'll go ahead and provisionally appoint that office.
Thank you.
I look over your paperwork and I find probable cause for the charge. Ms. Smith, go right ahead with any bond argument.
And I did not see any prior record for her Florida. Does she have something?
It looks like she's got a little something out of Montana,
Oh,
Missoula County, Montana.
I don't have access to that.
Yeah, let me see if it doesn't look like it was dismissed though.
Oh.
It's DUI from like 20 years ago.
That what it was.
Yeah, Montana.
Yeah. Unless basically they're alleging that at the time there was a child in the car. Yeah,
Yeah, I was 19.
okay. So you're asking for,
I was just gonna ask for reduced bond. I didn't know about the DUI in Montana.
ma'am, having found probable cause, going to set your bond at $2,500. Going to make it a condition of pretrial release. If you're
Okay.
able to post that bond, you must immediately check in with pretrial release services here in Bartow. Sign
Today?
up in person. If you bond out today, you still probably won't make it there before they close, so it'll have to be
Or
tomorrow.
tomorrow. Okay.
Yeah, you're open Monday to Friday, like normal business hours. Sign up with them in person, calling them on Mondays. You have all the standard pretrial release conditions everybody else has. Based upon the allegations of drinking, I'm going to require that you not possess or consume any alcohol. You not go to any bars, nightclubs, or lounges. You'll be subject to random breath testing, as well as conditions 16, 17, and 18. If you're able to post those bonds, you must immediately check it. I'm sorry. 16, 17, and 18 is you can't have weapons, firearms, ammunition, or knives.
Sure.
17 says you can't have any intentional contact with the listed victim, directly, indirectly, or through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. And since you did reside with the victim prior to being arrested, you get to go back to that home one time with the police within 24 hours, 48
Okay.
hours.
I have a question. Does that include like getting my car and all of my stuff? Like obviously not all my belongings. I know that's another time, but like get my car, get my dogs, then.
Yes, ma'am. That's kind of what it's,
Yeah, just because like everything's there. So this is kind of like, yeah, I don't know
Yeah.
what to do with the dogs and stuff. Okay.
Yeah, I lump all that stuff under the term essentials, medicine,
Sure.
clothing, your dogs, your car. But at the
Thank you
same
for
time,
clarifying that.
I don't think the police are probably going to stand around or wait around while you back up a
Right.
U-Haul and boot it up. So you might have to make arrangements for the full move out at a later date.
Yeah. Okay.
Okay, ma'am. Have a nice day.
Thank you.
Valerie Stafford.
Sir.
Stafford, you're charged with domestic violence battery. Are you planning on hiring a lawyer?
No, I need an attorney, sir.
I'll appoint the public defender. Looked over your paperwork, finding probable cause, setting your bond at 2,500, making it a condition of pretrial release with all the standard conditions, including Monday call-in. You have special conditions 13 and 14, which is no alcohol or bars, random breath. You have 16, 17, and 18, which is no weapons or firearms, no contact with the victim, and you get to go back one time with the police to get your stuff. Have a nice day, ma'am. Taylor Sturgill. Ms. Sturgill, you're charged with domestic violence battery. Are you planning on hiring a lawyer, or do you want the public defender?
Public defender.
All right, I'll go ahead and appoint that office to represent you. Ma'am, I've looked over the paperwork and I find probable cause. Ms. Smith, you want to be heard as it relates to bonds?
Yes, Your Honor. I didn't see any prior record for her in Florida. And the alleged victim actually spoke with pretrial release services and said they do want to have contact with her. How there has been verbal previous violence, but not physical. And apparently there's some other things that they want done, but it looks like they do want to have some contact with her. I didn't know if she was eligible to be straight pretrial release or if she could get a reduced bond on this.
Ma'am, I'm going to go ahead, having found probable cause, and I will reduce your bond. It'll be 2,500, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial, sign up in person, calling them on Mondays. Ms. Smith, I'll agree that victim comment sheet was kind of, it wasn't black and white. There was some things that had to be interpreted there. So what I'm going to do, ma'am, is you have all the standard conditions everyone else has. Plus, I do believe at this early stage, special conditions 16, 17, and 18 is appropriate. 16 says you can't use, possess, or carry firearms, guns, weapons, ammunition, or knives. 17 says you can't have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from them. Him, his home, his vehicle, books, or where he goes to school. Since you resided there with him before your arrest, you get to go back one time within 48 hours with the police to get your essentials. Have a great day, ma'am.
Thank you.
You bet. Moving on to the men, I think we're up to Emmett Barnes, who's being held on a resisting without.
South County. Barnes was sent to South County.
He wasn't there. We didn't do him.
He's not here, Your Honor.
We have him as central, and now I admit sometimes those guys get transported, but we didn't have him at South, and they didn't bring him up. So y'all want to, Ms. Smith, bring him back tomorrow?
I'm trying to figure out why he has no bond. Otherwise.
Yeah. Any idea why he has no bond? If you, Ms. Smith, if you want to have his hearing without him here, I'm going to set him a bond at $1,000. But if you want him to be here.
If I did that, how would somebody allow him, tell him what his bond is so he can bond out today? Or I don't know how the procedure works.
I don't either.
Would have to have it reset for tomorrow because I don't know how the system works in that regard.
Sure. Yeah, like I said, I wish I had an explanation. I just know we did South County. We had some add-ons there from Central, but he wasn't one of them. And okay. I don't know if Miss, yeah. Were you able to hear that?
No, it was not.
3+ arrest in the last 6 months.
Okay.
That's something that you get held for with pretrial.
Okay, we just continue it tomorrow.
We'll bring back Emmett Barnes tomorrow, Madam Clerk. Carlton Bryce, Mr. Bryce being held on 2 charges, disorderly conduct, resisting an officer without violence. You want the public defender?
Yes, sir.
Appoint the public defender to represent you. I've looked over your paperwork. I find probable cause. Ms. Smith, go right ahead on any.
Yes, I didn't see any prior record for him. He's 18 years old. I would ask if he could be considered for straight pretrial release.
I'm a little reluctant to do that. He has no ties to Polk County. He's a resident of Hillsborough County. And it does look like he has let's just say he's not a stranger to the court system.
Okay, I just know it's just turned 18
Well,
last year, I guess.
yeah, it goes on and on and on.
I don't have the juvenile
Yeah.
stuff, so I didn't know.
Yeah, it's a long one.
Okay, never mind.
So, sir, if I'm probable cause, recognizing you live in Tampa, I do think elevated bonds are appropriate. I'm going to double the disorderly conduct to 500. I'm going to enhance the resisting to 1,500. It's 2,000 total. Have a great day.
Yes, sir.
I see it, that's all.
Adam Chipko?
My boss, $2,000.
Yes.
Mr. Chipko, you're charged with possession of meth, possession of fentanyl, possession of Xanax, known as alprazolam, and possession of paraphernalia. Do you want the public defender?
Sure.
Appoint them. Looked over your paperwork, finding probable cause, setting your bond at 1,000 on the paraphernalia. It'll be 5,000 for each of the remaining 3 felonies. 16,000 total. Have a great day. Arsenio Clemens? Mr. Clemens, you're domestic violence battery. Do you want the public defender?
I believe I'm gonna get a lawyer if I have to when I get out. I don't really know yet, Your Honor. I'm gonna need one.
Sure.
Yes,
I'll
sir.
appoint the public defender for the time being, provisionally
Yes,
appoint
sir.
them.
Okay,
Mr.
thank you.
Clemens, I looked over your paperwork. I find probable cause. Going to set your bond at $5,000, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, calling them on Mondays. All the standard conditions plus special conditions 16, 17, and 18, which is no weapons or firearms can be possessed, no intentional contact with the victim, and you get to go back one time with the police within 48 hours of getting out of jail to get your stuff. Have a great day, sir.
All right, thank you, Your Honor.
Yes, sir. Jeremy Collins?
And Henderson's office, actually, they're doing all the charges, these are for today.
All the charges? All right. Just the first things first, my document shows,
We did the arson yesterday by itself. The judge said didn't have the affidavit for all this other stuff yesterday. So we did the arson yesterday. It was a totally different incident involving where he lived with his roommate. And so that's set for a pretrial detention hearing coming this Thursday. These are 2 totally different incidences and they're 2 different affidavits.
yeah, what I was just going to say is clearly from the affidavit that I reviewed, again, I didn't, until you just said it, I didn't even know he was here yesterday or over the weekend. But from the affidavit, it's 5 different charges, but 3 counts apiece. So just common math would say that's 15 counts.
There's another affidavit. That's why it gets to 4 each for that. There's 2. He's a total of 3 different affidavits, and one of them was arson yesterday, and then he's got 2 different affidavits for the charges he's here for today. One of them has 3 charges in each count. The other one has 1 charge in each count. Instead of putting them all together as 4, they put them separated them.
But just so you know, he's only here. If you do that math, that would be 5 times 4, 20. He's only here for 14 charges. So that's what I was going to say off the bat is the jail had him on this document I'm using as 14, which clearly it should be 15 from the affidavit. Now, if there's a second affidavit adding 5 more charges, then it should be 20. And that's what the clerk has, 20.
And he's booked in on 21 charges in all, including the arson.
Yeah.
So there's a separate affidavit for the other count. So he is booked in on 21 charges, including the arson that we did yesterday.
Yeah. So document only has 14.
Yeah, he should be here today.
Okay.
Is that not on the first appearance order?
Of course, again, I haven't even got there. I'm just telling you, the jail, when they send me this list, like this is what's his first appearance today, Judge.
Right.
There's 13.
I understand it is wrong. Sometimes.
I'll have,
Excuse me, Judge. Sir, I also want to hire an attorney too.
we're working this out. Not your turn yet. Yes, ma'am.
Yesterday was.
Sir, you're interrupting me, okay? You're interrupting now, and I don't appreciate that. So please just keep your comments to yourself. And when we get done talking with the attorneys, I'll conduct your hearing. I'm sorry, go right
It
ahead.
should be 20 today then.
Yeah, for some reason on this one, there's an extra trespass, so it should be 19. The one that was in showcase only had the 19 other charges, not including them. So he's here on 19. Is the affidavit, there's one affidavit that lists 3 of each, and then another one that includes 1 of each, not including the extra.
Oh, I see that. Yeah, the sheet that I have shows these books charges. That's violation of Polk County burn ban. Is that the one that only has 1 on the other one? No, it's not. What is it charged at?
Yes. The ones, I got this one, has 3.
I guess a trespass. No, he's actually booked in on 4 trespasses.
This one. So what happened on the arson yesterday?
I didn't have a challenge on that again because it was a different incident involving a residence with his roommate. So it's set for preliminary hearing, pretrial detention hearing on Thursday.
So he's being held for that.
So he's being held for that,
Okay.
right? And then we're supposed to be brought back today on all these other charges, which the judge Winston didn't have yesterday. So we just sent them all over for today.
The booking sheet has 4 trespasses, but in total on both of the affidavits, there's only 3.
Right. One on one trespass right off the bat.
Well, our passes on it. And
I think I know where we got 19 because the one I'm seeing that has just comparing apples to apples, they have intentional burning of lands. They have that one. Then they have burning it during an emergency. Yeah, failure to control or report dangerous fire, violation of Polk County burn ban. But they do not on the second affidavit. So it's just the 4. So 19.
Oh, I still have a problem with challenges on 19.
Once I felt comfortable on where we got to 19, then I'm happy to hear your probable cause challenge. Go right ahead.
He's charged with all these charges based entirely on circumstantial evidence. My understanding is where the fires were located, they found a receipt from Publix, I guess at the location, that's how I read it. And then they went back to location to see all the items in the receipt that they found at the incident location were the fires. And it came back to him in the video of the Publix. And they have video surveillance showing the house with someone. They don't know that they didn't say who it was, but wearing a flat top and jeans, leaving the scenes of the fires. But there's no allegation that he's the one that had anything to do with any of these fires. There's no witness that said, oh, Mr. Collins was there. I see him there. I can identify him as the one that started these fires. There's no admission from Mr. Collins that, yes, I did start all these fires. There's no actual video that indicates that they have the surveillance, but they don't have they say that in the surveillance, they can totally identify that that's Mr. Collins in the surveillance. We don't have that either. I don't know how you can be charged with all of this without more evidence than what we have more evidence than what we have in the police. The crime scene. I just don't see how he can be charged with all of this. That's my probable cause challenge for all counts.
Fellas, if y'all don't mind keeping it down, I can hear everything y'all are saying and it's kind of being a little bit disruptive.
And I would point out that, you know, the ticket or whatever that they found, that could have come from anyone. I mean, get from the grocery store. I mean, it could end up anywhere. I mean, just because his wasn't the crime scene doesn't mean it was.
Right, just pointing out a line in the 3rd paragraph, video surveillance footage, they're talking about from the Publix, shows the defendant positively identified by your affiant and Lieutenant Snyder from a previous arrest of the defendant purchasing the items. and leaving the public store prior to heading north towards the fire scene.
Which affidavit? Is that the one with the 1 or the
The
3?
3. Yeah,
If I can find that. I was looking at the one from the 1, which was first. And then they added 3 more based on the first one, which I was reading from, that I'm saying that there wasn't any probable cause for. And then the second one, I just have the 3rd paragraph. Hold on a second. It says, video from the house near.
above
That's
that.
from the previous arrest. Searching the items and leaving the public store. Is that what you're talking about? Heading north towards the fire scene. Now, how is he, I guess my question is, how is he identified by the officers if they're using the other incident that occurred first, the first 4 counts, which weren't 3, which when you look at that affidavit, which whoever is in the video, they're identifying from the other video that they saw. So I don't know that they know for a fact that it's him, the way I'm reading these affidavits. Because in the second affidavit with the 3 counts for each, they're basing it on what they saw in the first affidavit from when they had the 1 count for each thing. And there's, I guess, a person, I just don't see how they're saying it's him based on a ticket from the public.
Let me read the one with the 1, and then I can hear from the state and then give you guys a ruling. No, not that, the one that's, that one. That one.
Well, he was identified from, it says, from a previous arrest, they was identified purchasing items from Publix. I didn't, let me read this again. So they identified him from going to Publix, I get that. And then apparently been arrested before and from purchasing the items heading north towards the fire scene. But again, I still say that's not a, it's just circumstantial evidence.
You don't believe circumstantial evidence can be the basis for probable cause?
Well, in this case, I just don't even think there's enough for that, but that's just, my opinion based on what I read. It's a very, I just don't see that there's enough based on 1 receipt from Publix being found at a crime scene.
Well, when you found it, it sounds like items that were used to set the fire. Is how I read it.
I didn't read it.
Yeah,
Where
yeah.
did it say that?
That says, throughout the investigation of the fire, items purchased from a Publix grocery store were located.
Yeah, it doesn't say what they were.
I know, I'm just telling you, that's what, I'm just telling you, there were items that were purchased. Now, it'd be nice if they would tell me, Judge, there's Publix lighter fluid here, or there's Publix, charcoal here. I don't know, but whatever it is, it'd be nice to know what that is. But clearly they have Publix items that were found throughout the investigation at the crime scene. They didn't go to the local public store and through with the people that were able to, hypothetically, if it was lighter fluid, maybe they've only sold 3 or 4 lighter fluids, in the last week. So then they can pull up a receipt to show what was purchased, and then they could zero in on the camera. Well, son of a gun, they've identified this individual as someone they knew from a previous arrest as the one that's doing the purchasing of the items that were found throughout. And then he's heading north towards I agree, it's circumstantial. I mean, it is. I just think that before we discount circumstantial, know that there's a lot of people serving times in prison on wholly circumstantial cases. So, but no, I disagree with you. I think at this stage of the case, it's not beyond and to the exclusion of every reasonable doubt. It's not clear and convincing. It's not standards such as the state has, which substantial likelihood of success at trial, which is a filing type of a standard, but probable cause. So yeah, I believe there's probable cause based upon the affidavits. You want to be heard as it relates to bonds, Ms. Smith?
I would just ask for reasonable bonds. I would know, as we all know, he is being held no bond on arson charge, but he has a chance for hearing on that on Thursday to hopefully get a bond on Thursday on that charge. I would just ask for reasonable bonds on these cases.
Okay. Just to make it clear, Mr. Collins, I'm sorry, sir, we kind of got sidetracked, but let me tell you what your 19 charges are. You're
Yes,
here
sir.
on counts of intentional burning of lands. You're here on 4 separate counts of burning during an emergency drought conditions. You're here on 4 counts of failure to control or report a dangerous fire. You're here on 3 counts of trespass, and you're here on 4 counts of violation of Polk County burn ban, a county ordinance. Do you want me to appoint the public defender to represent you on these 19 charges?
Absolutely.
I'm happy to appoint that office to represent you.
Thanks,
Sir,
sir.
we just had a discussion, and again, it was a little confusing for me because when I come in to do first appearances on Monday, I wasn't the judge that did it over the weekend, and I wasn't sure that you had got, we're already here. But we've sorted it out. I appreciate your patience.
Yes, sir.
We've sorted it out. I find probable cause for all 19. Again, the standard for today is a low standard relative to the very high standard that's needed to convict you at trial. So it's a very low bar, relatively speaking. So I find probable cause on the 4 counts of intentional burning of lands. I'm going to set your bond at $5,000 apiece. On the 4 counts of burning during emergency drought, it'll be $250 per count. On the 4 counts of failure to control or report a dangerous fire, I'll set it at $250 apiece. On the 4 counts of violation of Polk County burn ban, it's a county ordinance, $250 apiece. And on the 3 counts of trespass, it'll be $1,000 per count. Have a nice day, sir.
Yes, sir. Please let me go.
He's on probation. So was that addressed this weekend?
I don't remember. We had
Hold up.
97.
How many?
We had 97.
Oh,
yeah.
goodness.
So I honestly don't recall whether we did probation or not. If that was done by Judge.
By your probation yesterday?
I'm not on probation anymore. I violated last year, and I do my 60 days.
It may have been something, yeah, he may have done that. We may have to.
Can you-
yesterday?
Yeah, can you, there's pretrial showing me a probation case of 24. Can you just look to see? And that case number is 24MM9025. Mr. Collins says he's not on probation anymore. With that age of that case, I wouldn't be surprised if he's accurate. But I just want to double check because pretrial identified it. Again, Ms. Smith?
I mean, I'm looking at the showcase. It shows that probation was revoked on October 2025 and the 9/25.
Yeah, that sounds like what Mr. Collins was saying. So, okay. So there's no Parker situation. There's no instanter situation. He's got bonds on these and he's got a arson motion for pretrial detention later in the week. All right, moving right along.
Thank you.
Passport counts being, yes, all those are county ordinances. 250 on all. So 5,000 on the felonies, 1,000 on the trespasses, 250 on everything else.
Yeah. Thank you.
You bet. Tyler Ha,
Same as your foot fingers up. Just want to be heard regarding bond.
Mr. Ha, you're charged with domestic violence battery. Do you want the public defender?
Yes.
I'll appoint them. I reviewed your affidavit, finding probable cause. Ms. Smith, go right ahead.
You know, I didn't see any prior record for him in Florida. I don't know if he has any record elsewhere. It looks like the alleged had thrown a pot of water and threw at the alleged victim. And then I don't know that she got hit with the water. But in any event, I would just ask for straight pretrial release or low bond if he doesn't have any prior record elsewhere. And an officer, I don't believe, says they didn't even observe any physical marks on her or anything, or any water or anything, so I don't know that any water even touched her.
Yeah, but that's not the big part of it. It says the allegation is he pushed her towards her left face and she fell towards the wall. So the water, I agree with you, is not the most important aspect. All right, Mr. Hoff, having found probable cause, I am going to give you a lower bond. I will set your bond at $2,000 cash or surety, make it a condition of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial, sign up in person, calling on Mondays, all the standard conditions plus special conditions 16, 17, 18. 16 says you can't possess weapons or firearms or ammunition. 17 says you can't have intentional contact with the victim. Stay 500 feet away from her, her home, her vehicles, where she works or where she goes to school. Since you resided with her prior to your arrest, you get at home one time within 48 hours with the police to get your essentials. Have a nice day, sir. Cameron Holder. Yes. Yes. No, I might not have even asked him. Yeah. So, I'm going to appoint Mr. Ha, the public defender. Cameron Holder, sir, you're charged with failing to appear for drug court. I cannot appoint the public defender. I find probable cause, and I'm going to hold you no bond, and we're going to send you to see Judge Pinkett on the 17th. Have a great day.
They don't have court tomorrow?
No.
Yeah. Reynardo Hudson. Mr. Hudson, you're charged with domestic violence battery. It's with a prior conviction, making it a felony. Do you want the public defender?
Yes.
I'll appoint him to represent you. Sir, I've looked over your paperwork, finding probable cause, setting your bond at $5,000, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial release, sign up in person, calling them on Mondays, all the standard conditions plus special conditions 16 and 17. And let me double check here.
I've never had a conviction in domestic battery.
You take
This is my first conviction this is my first charge in domestic battery.
It doesn't have to be domestic. It can be any battery, including battery on a police officer. It says here, and again, I'm not saying this is true. I'm just telling you what they're alleging, that you, suspect has a prior conviction of battery on July 14, 2010 in a felony case number that was investigated by Tampa PD. So it can be a battery on a policeman, a battery on a firefighter, punching a guy at a bar. I mean, it doesn't have to be domestic. All right, sir. So pretrial release, $5,000 bond, standard conditions, special conditions, 16 and 17. It looks like y'all have different addresses, so no reason for 18. And just so you know, what I said to someone earlier, the allegation is this act of violence took place in front of a child. So I have no choice but to report this to DCF. That's what I will do. Have a great day, sir. Princeton Hunt.
Sanderson Public Defender's Office. We were pointing to this case yesterday. I had probable cause challenge because nothing was tested. So I have not received any new report from the state saying that the alleged cannabis paraphernalia were tested. So I'm asking for him to be released on his own recognizance.
So Judge instead brought it back today because it wasn't tested.
Yeah, there's no probable cause yesterday.
Your argument was it wasn't tested. Well, that's what I'm asking. Your argument was it wasn't tested.
Correct.
She agreed with your argument, brought it back today, and there's nothing new.
That's my understanding.
Okay.
At this time, your state has additional information to provide.
All right, Mr. Hunt. I'm going to ROR you, finding no probable cause on these two charges. Have a great day, sir. That doesn't mean the charges go away. It means you're not in jail. So you may be
Yes, sir.
getting notice to show up for court because the state gets the final say on whether or not you get charged or not.
Yes,
Have a
sir.
great
Thank you. Thank you so much.
Johnson. Mr. Johnson, you're charged with possession of drug paraphernalia, possession of cannabis over 20 grams, and petty theft. You want me to appoint the public defender?
Yes, Your Honor.
I'll appoint the public defender to represent you. Finding probable cause, Ms. Smith, go right ahead.
I just didn't see any prior record for him. I know he's around 19 years old, I believe, if I can do the math right. Yeah, he's 19. I didn't see any prior record. I would just ask for reduced bonds.
Well, what scares me, I was going the other direction. I was going to enhance his bonds because he's traveling through working for a circus. History says.
He's got a prior record next fire.
I mean,
his address is listed as Lake Wales, so.
it was Lake Wales because that's the Eagle Ridge Drive, which is the Eagle Ridge Mall where the circus was being put on. So he's a traveling, use the word carny. He's nomadic. He's moving along. So if I give him a lower bond and he bonds out, he may be in another state later this week with a likelihood of or potential for him not to come back. So I was viewing it as not a good thing, but a no ties to the community kind of thing that would give him a higher bond.
I do live on the Noble Drive. Very lively.
All right, sir, hold tight. Your hearing's up here, and when you're talking, it kind of distracts me and the attorney who's advocating on your behalf. So kind of stay focused up here if you could, okay?
So they put that address just because the circus was there?
That's my
Well,
determination.
I don't think he has any prior record, so I wouldn't think bond should be enhanced if he has no record, just because he's working for a circus.
I'm not saying that working for a circus is cause to have a higher bond. I'm saying having no ties to the community and no fixed address is probably cause for a higher bond. Tell you what I'll do. I was going to enhance them. I'm going to enhance them less. How about that? Mr. Johnson, first things first, you want the public defender. You're here on 3 charges. A petty theft of a shopping cart, possession of cannabis over 20 grams, and possession of drug paraphernalia. Do you want me to appoint the public defender?
Yes, Your Honor.
I'll go ahead and appoint that office to represent you. Yeah, the pretrial release has his address in Indiana. He's just here traveling with a circus.
But he has no prior record.
All right, sir, having found probable cause, setting your bond at $1,500 on the paraphernalia, $1,500 on the petty theft, and setting your bond at $6,000 on the cannabis. Have a great day.
So my bond is 9,000 for you?
Yes, sir.
9,000.
Next up, we have Jerry Schaefer. Mr. Schaefer, you're charged with 4 things: resisting without, possession of cocaine, possession of fentanyl, possession of drug paraphernalia. You want the public defender?
Yes, sir.
Point him. Looked over your paperwork, finding probable cause, noticing you have an open case that's a felony with an extensive prior history. The charges for that 25 CF, if you got a minute. So, sir, I've looked over your paperwork. I do find probable cause for these 4. It does look like your open case is the same charge of cocaine and paraphernalia. Enhanced bonds are appropriate. Setting your bond at $2,500 on the resisting without, $2,500 on the paraphernalia, $7,500 for both the cocaine and the fentanyl. Add it all up, it's $20,000. Because I found probable cause for these 4, I am going to take you into custody on 25 CF 11705 and hold you no bond pursuant to the authority of Parker versus State and appoint the public defender.
I believe he has a Brandon Jones representing him.
Okay. If you have Mr. Jones, he'll continue to represent you. Have a nice day, sir.
Okay, second cell.
Williamson? Folks, if we hurry, I can get done by 3. I don't think that's ever happened, so let's talk fast. Mr. Williamson, you're charged with domestic violence assault. Would you like the public defender?
Yes, for now. I think I'll be able to find one once I get home. Yes, sir.
Okay, fair enough, sir. I'll provisionally appoint the public defender to represent you. Sir, I've looked over your affidavit. I find probable cause. Decided to set your bond at $2,000 cash or surety and make it a condition of pretrial release. You post that bond, you must immediately check in with pretrial, sign up in person, calling them on Mondays, all the standard conditions plus 16 and 17, which is no weapons or firearms or ammunition in your possession and no intentional contact with the victim. Stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. Have a great day. I didn't think he did. Based upon, I started to say that and then I marked through it when I determined that he did not. In fact, based upon the victim's comment sheet, she has moved out.
Okay, so you can move there.
Yeah, that's what made me. So she has already said she's moved out, so you get to go back to that home that you shared with her because she ain't there anymore. You agree with that? Yeah. All right. Have a great day.
Thank you.
John Wimberly.
Yes, sir.
Mr. Wimberly, you're charged with 2 new charges of burglary of a structure and felony petty theft. It looks like you have 5 VOPs that will put you on probation for criminal mischief, grand theft of a vehicle, burglary, criminal mischief, and grand theft of a motor vehicle. Real quick, are those cases, he's being supervised here out of state? Is that what y'all have determined? I didn't have a lot of information to go on.
Yes, sir. I just got out of prison December 5th and home plan back to Florida, and I was living in a trailer park, and this guy gave me a washer.
Don't talk about the case, sir. You really aren't going to do it. I just wanted to know if this was you're being supervised on a Florida case or a out of Florida case.
Out of state case.
Okay,
I'm on parole.
Local probation officers.
Yeah, I'm on parole out of I'm interstate compacted here. My parole officer's name Miss Morris.
So
Parole out of Bartow.
okay.
I don't know if this means he's on probation. I mean, it's
They said parole. That's kind of what I'm on. Again, it's their interstate, and I don't see these a lot, and I just wanted to get your take on what you think I can do or should do.
I got an appointment with Social Security tomorrow.
I mean, I'm gonna have to defer to the court on this. I apologize.
I mean, if it's a warrantless, so it's not even like a fugitive from justice. So am I even able to appoint the public defender on a probation case from, say, hypothetically, Georgia?
Well, yes, I guess that would, if you consider that a fugitive case.
Okay.
We could do that.
That's right. That's kind of where I was going.
Then they'll undo it at the next hearing.
Okay. So, sir, you want me to appoint the public defender on the 2 new plus the 5 VOPs, 5 paroles?
I don't. That's already been taken care of, sir. I don't know why I'm only here because I got somebody give me a washer that belonged to somebody else.
Do you want a public defender?
Yes, sir. Yes, sir. I need a public defender.
I'll appoint the public defender on the 2 new ones, and because Ms. Smith thinks that this would be treated as a fugitive potentially, we'll appoint the public defender to help you on the extradition. Sir, I find probable cause for all these charges. I'm going to set your bond at $7,500 on the burglary, $2,500 on the felony petty. I'm sorry, $7,500 on the burglary and $7,500 on the felony petty theft. Now, you would be held no bond on the 5 interstate VOP/paroles, but those are things you can discuss with a circuit judge when you go to that extradition hearing quickly. You'll have it's a quick turnaround. It's 316. So those out of state parole things go quickly. You'll go see the judge on 316. Your arraignment for the 2 new charges is 414. Have a great day, sir. All right. Okay. I think that's a couple minutes fast. I think it's 2:59 and we're done for the day. We're done for the day.
Judge,